on your business with Accent Nominees. So last week we had an introduction on what we'll be looking at for the next few weeks, and that is your business and law. So if this is your first time on this channel, I would encourage you to check our previous videos. We had a series on what next after your business registration. So we talked about several things that you need to avert your mind to as a business owner, as a startup, or someone who knows someone who is into one business or the other. So that series is just to guide entrepreneurs out there on the things that they need to know after registering their businesses. So this week we'll be starting the series Your Business and the Law officially, and we'll be starting with what you need to know about the law of contracts. So we'll be looking at what contract is today and what you need to know about the law of contract and why you need contractual agreements in your business relations. So to start with, when you hear the word contract, what comes to mind? And I remember before now, like while I was still in secondary school, sometimes when I hear contract, what comes to my mind was like someone getting a contract. I just keep hearing the word contract. I didn't really have a full understanding of what contract is. So I kind of limited my definition of contract to someone getting. I do hear people say someone won an award of a contractual awards and like. So I just limited my understanding of contract to someone getting a project to execute. Let's say you got a contract to fix Lagos Ibadan Express Road. So those were like the limited understanding I had on the word contract. But if you look at it, basically, contract is just it's an understanding, it's a relationship between two or more people to carry out a particular obligation with an understanding that it is going to be legally enforced or is going to be binding on both of them, or both parties or all parties to the agreement. So a contract is an agreement, basically. That's just like one word definition for it. A contract is an agreement and it is entered into between parties. So it is a mutual relationship. So it is not someone forcing you to do something, but it is an agreement between two parties or more people, and it's always about, oh, you do this, I'll do this. So when you talk about contracts, you get to hear words like offer, you get to hear words like acceptance, you get to hear words like capacity, consideration, intention to create legal relations. So these are elements. These are when you hear the word contract, or when someone says he has a contract with someone, all of these elements, they are all present in a contract. So a contract always starts with an offer, someone offering to sell something or offering services. And when you say offer too, so it's not just like offering, like doing, but it's like making a request to do. So like, I'm offering you this, oh, take this and you give me this in return. So it's just like this trade by barter system. So it's a contract. So I give you yam, you need rice, I have yam, so take yam for rice, give me rice for yam. So it's like that. So a contract is always, there's always an obligation obligation to be done or to be performed by one party to the other. So your own obligation in a contract can just be to pay the person to do the job, or to pay someone to give you a particular product, or to supply some goods to you. The other party's obligation might be to render the service, or to supply the good, or to produce something. And in all of this, there's this intention to create legal relations. And when you say legal relations, it is to the extent that where you fail to do what you need to do from what we've agreed upon, then I can file an action in court, or I can commence an arbitration section, or I can write to you to perform that contract, or to pay me back, or to compensate me for loss. Because sometimes when people default in performing their part of the contract, there's always like a wrong done to the other person. So when we talk about contracts too, in business relations, people enter into contracts every day, and you wouldn't want to imagine the number of contracts people have entered into today, either orally or pen down. So but sometimes people limit their understanding of contracts to only when something is written down. So you can have a contract with someone without putting it down in black and white, though there has been a lot of challenges trying to enforce that, especially where you don't even have witnesses, people who can come to say, oh, I was there when these parties agreed to do this thing. So talking about what you need to know about the law of contracts, just as our topic is scheduled for today. So today we'll just let you know why you need to have a contract agreement for all your business transactions. Yes, it might look like a burden, but then if you consider the pros and cons, you discover that it is always better you have things done properly for your business, because it will not just save you costs. Yes, sometimes people can feel that, oh, if I get someone to sign an agreement, so if I engage a lawyer to prepare an agreement for me, I'm going to spend, and rather than just spend and engage someone to draft the necessary agreement, the necessary contract agreement to be executed between the person I want to relate with, business relationship now, I'd rather just have my conversation with the person and we are good to go. But you discover that you save yourself some cost, not even some, you save yourself huge amounts of money that you should have used for your business in cases of default. Because sometimes when people default in meeting up with their contractual obligations, sometimes it may require that you start all over again, or it may even require that you don't, even if you are to start all over again, it's going to cost you a lot. So you may want to get a refund, especially where consideration has passed, like you've paid the person, you've mobilized the person. So it's going to cost you to get the person to refund you. It's going to cost you your time. It's going to cost you a lot of things, even emotional and mental stress, like all of this. So these are things that you can avoid in your business relation when you are entering into any agreement. So for your business, for every business transaction where you are getting someone to either supply you or to render a particular service to you, and for sake of confidentiality, we still had a conversation at work today where there was a breach of an agreement. Someone, a business owner, contracted someone to do something, and if you have to look at what the relationship was, basically it's not something that people would want to avert their mind to get a contract or to get an agreement for. But then if there was an agreement between the business owner and the service provider, they would have been able to clear some self of the mess and the liabilities and things they are trying to wrap their head on now. So this is why it is very important to have a contract agreement, or to have an agreement, to have a document. So okay, let me, if the word agreement can kind of look too legal, to have a document, it can be as simple as a one-page document to say that, oh, this is the understanding between this person and this person. So a contract basically is an agreement. A contractual agreement is a document that talks about the purpose. So if you are to look at a contractual agreement, you see the parties to the agreement. That's the first thing you see, the parties to the agreement. So you know the parties to the agreement lets you know the people that document bind, or the people who is going to be liable for any default on what is stated in that agreement. So your contractual agreement, or your contract document, or any document at all that you are using or you are relying upon when you are entering into a relationship with someone, it should clearly state the names of the parties. So when you say the parties, that's the people involved. So it can be your business, it can be the other person's business, it can be an agreement with someone in his own individual capacity, and it can also be entered into by you in your own individual capacity too. So when you are entering into an agreement, and when the document is being presented to you, and you are seeing business names, and when in law a business name is not a registered business name, is not a person in the legal sense. So that is to say, a registered business name cannot enter an agreement in the name of that business name. So if you are contracting someone to do something, there's a contract agreement between you and someone to do something, and that person is carrying on that business under a business name, but the person is providing service or supplying goods to you with his business name, it is advised that you have the name of the owner of that business stated on the contract document, so that when you want to enforce, there won't be any issue of someone saying, oh, there is no legal agreement between this particular person, or this person is not a juristic person, and the likes. So even at the time of entering into the agreement, you should pay close attention to something as simple as the name of the person you are entering into the agreement with. So if it is a company, yes, a company can enter into an agreement in its own name. If it is a business name, just request that the person put his own name there, because if there's going to be any liability, it is the business owner, the sole proprietor, that is going to be liable for all of this. So in a contract agreement, you see the name of the parties. So this clearly spells out, oh, when there's a default, this is who I'm going to hold accountable. When this needs to be done, this is the person I'm accountable to. And when you want to refund, if there's a need to refund, and there's a need to compensate you, you know who you are compensating. So no one will just come and say, oh, I was there when the agreement was entered into then, or something happened, I want to lay claim to compensation. So the contract agreement states the parties to the transaction. Then another thing that you see in a contract agreement is it always states the purpose, the intent. Why is this agreement entered into? What is the obligation? What is the background? Why are they entering into this contract agreement? So you also see that. Then another thing that you should have in your contract agreement is the obligations of both parties. Oh, who is doing what? Who is providing the fund? If it's, let's say, a contract to execute a project, who is providing the fund? How is the fund to be made? In what? If it's payment by installment, oh, installment should be made at so date. How much is to be paid per time? And talking about what is to be done for the other party who is also rendering the service or supplying the goods. What is the person supplying? Is there a quantity? Are you to supply 100 tons or 50 tons? At what time are you to supply? Where are you to supply? All of these things. So you don't just enter into business relationship with people on the phone alone. Yes, we are in a system where you can easily get suppliers, reach out to suppliers, and you place order for things online. But don't just leave everything at that. Ensure that there is a document. Even if you are trading online, ensure that you have a document to say that, oh, I'm placing order for this is one where you have to deliver it. And even when you check online, if you are placing order for things online, there's always an address for delivery, there's a timeline for delivery, and all of that. So if you have all of these things documented, it will save you time. It will save you your time, it will save you cost, and all, it will save you a lot of things. So that's why it is always advised that you don't just end all your negotiations on the phone, or you end it at a Zoom meeting where everybody meet to talk and you just transfer money, because now it's a cashless age we are now. So you can even transfer money. You can start and conclude business transaction with someone without seeing them. But as much as it is easy to have all of this carried on without even getting to meet the person face to face, a document can still be signed between both parties. You can affix your electronic signature, and the law recognizes that. So gone are the days where people can have challenges saying that, oh, this is an electronic signature, you were not there, you don't know if the person signed it or not. But in this age now, the law now recognizes electronic signature, so you can sign a document without even seeing the person, as long as there is mutual understanding. So that's why we said, when you talk about the law of contracts, there should be an offer, there should be an acceptance by someone, there should be consideration. there should be the person you're entering into that contract, you should have that capacity to enter into the contract. And that's why I've talked about, if you're entering into the business relation or the agreement, if it is between a business name owner or a registered business name. A registered business name does not have capacity to enter into an agreement, but the agreement should be entered into by the owner of the business. So you can see, for example, let's say Adedamola as a business name. So if you want to enter into any agreement, or if you are signing any contracts with Adedamola, it should be Adedamola trading under the name and style of my business. So you don't just put my business name there alone, for if you want to really save yourself of some legal tussles. So your agreement, like I said, should outline everything that needs to be done. Don't leave any room for anything. Like, try to be very detailed in your in what is documented in the contract agreement, so that everybody knows that these are my obligations, these are my duties, this is what I need to do, and where I fail to do this. Your agreement should also state, if possible, penalties for defaults. If there is a default, what is going to be the remedy to the other party? Or if someone is withdrawing from the contract, because we've seen cases where you send money to someone and at the end of the day the person tells you, oh, I'm no longer interested in this transaction, take your money back. But this is money that you've transferred to the person, like let's say 6 months ago, and you were expecting the person to perform the contracts, and 6 months after the person is saying, I'm no longer interested in this transaction, take your money. You've wasted some time. So if you know that, oh, I would want to ask for compensation, you can have it in your contract agreement. So it will even save you time when, if you have to go to court to enforce some things, then you have something tangible to rely on in the law court. So because a document speaks for itself. So if your agreement says that where you fail to do this and this is going to apply when you fail to do this, or even if you did but you do it at a later time than agreed. So that's why your document should be very detailed. If it's for performance of an act, you should state when it is going to be due. So you don't just leave it open-ended to say, oh, okay, you render this service to me for how long. So because it is when an agreement is detailed enough, that's when you can say there's a default. That's when you can say, oh, a default has not taken place. So no, someone will not just come to say, yes, you defaulted in doing your obligation, you've defaulted in performing what you need to perform. But if the document is clearly written to say that a default will arise in this particular situation, or there is a timeline, then if someone is coming, let's say you have a timeline to complete a project, let's say you are a real estate developer and someone has given you a contract to develop a particular estate, and you have a timeline of let's say 1 year, and just the second month the person is coming to say, oh, you've defaulted in the transaction, you've not completed the work, or you are still at the foundation level in the second month. The agreement says that this job is to be completed within a year. So if in the 5th month you've still not laid the foundation, you still have like 1 year. So the person cannot say that you've defaulted in performing your obligation, because there's a timeline. So it is when, let's say, in the 11th month and nothing has been done, or and like so, but then if you still have time, if you are still within time, then someone is coming to say there's a default, that you can present the document to the person to say that, oh, this is the timeline for this transaction, I'm still within this timeline. Then if the person goes to court, then you also have something to show to the court to say that this is still within this time frame. And if you are on the other side too, and the person has defaulted, like the scenario of completing a project within the timeline, and the timeline has exceeded, and the person is saying that no, you have not defaulted, there's no default and all. But when you have a clearly written document, it even saves your lawyers the stress of having to patch things sometimes. So this is why it is always advised that you have a document that clearly details out the obligations of the parties. And why should you have a contract agreement? Is that it protects both parties. So it protects not just your business, it also protects your personal yourself, your individual self. It also protects the person you're also entering into that agreement, just like I said, it's vice versa. So if you have a contract document, you can rely on what is stated in that document. Another party also can rely on what is stated in the document to his own advantage. So if issues arises, then what you've agreed upon, anyone can easily rethink. So no one will see black and call it white. So if your agreement clearly states, oh, this is what you need to do, then you can enforce it in the law court. So you've saved yourself the stress of having to say, oh, this was what you said, it was on WhatsApp call, or we had a Zoom meeting, or Mr. Lagbaja was there, and when you approach Mr. Lagbaja to come and give evidence in court, he tells you he's not available to give evidence. So you have saved yourself all of this stress if you have your documents, if you have your agreement documented. So in one word, this afternoon, if there's one thing that you'll be picking from today's conversation, is that for every relationship, as long as you are engaging the services of someone in your business, so it can be a service provider, and you can, after this conversation, you can outline in your business, you can outline your service providers. Though there are some service providers that you may not be able to have an agreement with. So for example, your electricity supply, your service provider, people that supply your electricity, like for example, Ikeja Electricity Company. Yes, to some extent there is an implied agreement to some extent, but then you can't say, yes, because I want to be using electricity, I can just come and sign contracts for you to supply me electricity in my business. But then there are still some implied contractual obligations that bind to an Ikeja electricity, where there's a difference. We've seen cases of people taking them to court. But then when I talk about outlining service providers, I'm not talking about IKEDC. So let's say you have you enjoy internet service for your business. You should have a contract between your internet provider, the internet company that provides internet services. So let's say you also have people who provide technology services for your business. You should have an agreement also that that regulates that relationship. So this is we're also in an era where people now engage services of digital marketers, people that assist them with their branding and the likes. So if you engage these people in your business too, you should have documents to say that, oh, as a digital marketer in my business, or all these social media influencers and like people that handle your social media pages. So if you have all of these people servicing your business, you should ensure that you have a document that spells out the services, the scope of service, so that when there is a default, you can even point it out to them. So when you talk about default, it's not all the time you go to court because there's a default. But when you have a default clause in your agreement, it helps you to be able to mark out and to map out things when someone is performing is part of the contract and when the other party is not performing. So you can easily point the person's attention to details when you have a document that spells out the obligations of parties. So when someone is not performing his obligation, or is not doing it as he should, you can refer the person to the contract to say that, oh, when you brought you on board this business, these are the things we expect you to do. And the person can look at it and put himself back on track. So this is another reason why you need to have your business well regulated under the law of contract. So, and also too, if you are in the business of supplying people things, it is not bad if you have a supply agreements where people can, it can be, like I said, can be a one-page document that people can easily sign when they place order for goods or when they request that you supply them things, so that you are well protected. Because another thing is when you've supplied people things, there are different provisions of the law that talks about when liability is said to have passed. So if I'm supplying you things, when can I say that it's no longer in my custody? And when someone is saying, oh, what you supply is bad and all, at what point can you say that, oh, this thing liability has passed to you? So it's no longer, if there's any error, if there's any damage to that particular good, it's no longer at my own instance. So all of these are things that you need to clearly spell out in any relationship or any contract you are signing. And when I say contract, agreement. So I believe that at the end of today's conversation, you've been able to pick one or two things from what we've discussed, and you find it very helpful in your business relation. So like I said, after this section, you can just outline service providers in your business and try to just check, do you have a document that regulates this transaction, or do you have a document that regulates this relationship, so that you can protect your business and the other party is also protected too. So thank you for joining us this afternoon, and we look forward to having another section which is still on your business and the law. So join us next week on Monday, as we'll be looking at another area of the law that you need to avert your mind to, another area of the law that your business needs to pay close attention to, so that your business is well protected. Thank you, and this is your Business with Accent Luminous. My name is Ade.